Welcome to TecHype, a show where we debunk misunderstandings around emerging technologies and the laws and policies that shape them. I'm your host, Brandie Nonnecke. In this TLDR, Too Long Didn't Read, we're giving you a quick update on the new amendments to SB-1047, California's controversial bill aimed at regulating advanced AI models. The bill is now sitting on Governor Newsom's desk, awaiting his decision. However, whether he will sign it into law, it's still unclear. Democratic members of Congress recently sent him a letter urging a veto. Their main argument? Well, they say SB 1047, it focuses too much on future existential risks and doesn't do enough to address current risks. They also warn that it could stifle innovation in California. And if you read between the lines, it's pretty clear they believe that large-scale AI governance strategies, they should be handled federally, not by individual states. But here's the catch. Congress is still stuck in a stalemate on many AI-related issues, so no federal bill is in sight yet. Now, let's dive into the 8 major amendments made to SB 1047. Number 1. Adjusting legal standards for open source. There was significant concern expressed by academia, civil society, industry, and government for how the bill would treat open source models. To address these concerns, the bill replaces reasonable assurance with reasonable care, a term with legal precedent. This ensures developers must act as a reasonable person would in these situations. It's not about just trying your best, it's about being reasonable under the law. Number 2, streamlining the regulatory structure. The previous version of the bill sought to establish the Frontier Model Division, which would have overseen compliance and update regulations. There have been several concerns that the Frontier Model Division could serve as a bottleneck, and at worst, release safety and security weaknesses that allow bad actors to exploit frontier models. In the current draft of the bill, the Frontier Model Division is now gone. Its duties have either been removed or moved to the Government Operations Agency, or GovOps. Developers must now send their safety protocols to the Attorney General, with some information made public and necessary redactions for safety. GovOps will now issue binding regulations for auditors and the Board of Frontier Models. Do you remember? Now that one's expanding from 5 members to 9, adding experts in cybersecurity and AI safety. Number 3, a $10 million fine-tuning cost threshold. If you remember our last TLDR on SB 1047, we mentioned that the bill considers a model that was trained at a rate of $100 million to be within scope. Now, there was confusion on the cost threshold, though, for fine-tuning a model. Now, in this current draft, fine-tuning a model over $10 million means that the fine-tuner now has full obligations as a developer under the Act. This threshold cannot be changed by GovOps. Number 4, removing criminal penalties for perjury. Now, this feature of the original draft of the bill was probably one of the most contentious. Now, in that previous draft of the bill, it included criminal penalties for developers who lie about ensuring the safety of the models. Now, in the current version, the certification of assurance of safety is being replaced by statements of compliance without the risk of perjury. Auditors who lie will face civil penalties. Number 5, clarifying harms. The bill now makes clear that developers are only responsible for harms they directly cause or enable. It also adds a new standard that information must be publicly accessible to an ordinary person, not just experts, to be excluded from liability. Number 6, clarifying shutdown requirements. Proponents of open source frontier models expressed a concern that requirements of shutting down a frontier model would stifle the development of open source frontier models. Shutdowns now apply only to models controlled by the developer, and now explicitly considers the risk to critical infrastructure caused by a shutdown. Number 7, amending whistleblower protections. Whistleblower protections for contractors have been relaxed. Contractors can now use the developer's whistleblowing process rather than setting up their own. Additionally, the Attorney General can redact information that may include proprietary information or information that causes unreasonable risk to public safety in public whistleblower reports. Number 8, requirements for specific tests are moved from pre-training to pre-deployment. This is one of the most important amendments. In our previous TLDR on the core components of SB-1047, we explained the difficulty of implementing safety tests and assuring risk mitigation of frontier models before training. Moving this requirement prior to deployment is much more feasible. Lastly, let's not forget that Anthropic, one of the industry's responsible AI leaders, issued a letter to the California legislature urging some changes. It appears in light of the amendments made to SB 1047, Anthropic is now in support of the bill. Will Governor Newsom sign it? He received the bill for review at 3 p.m. on September 9th. The clock is ticking. Stay tuned for more updates as we keep an eye on SB 1047 and the future of AI governance. Want to learn more about emerging technologies and the laws and policies that shape them? Check out our other video and podcast episodes at TecHype.org.